Welcome to Business Law course. This is the discussion about intellectual property on the subtopic copyright. In this section, we will discuss about copyright in joint cooperation and working relation. At the previous part, we've learned about who will be considered as the author and also copyright holder. But the previous part, we only talk about the simple situation, a singular action when the creator or the author is a singular person. But there is also another situation when the creation is made by more than one person or even made in an engagement of a working relationship. If I were writing a book just by myself, then it would be easy to determine that I am the author of the book as well as the copyright holder of the book. But what if the book is made by me with my other colleague? Or at the previous part, I've told you about the joint cooperation between John Lennon and Paul McCartney in writing songs. Or in Indonesia, for example, if you ever read the law book written by C.S.T. Kansil and Christine Kansil, so that was situation when the creation is made by more than one person. So how to determine who owns the creation if it's made by more than one person? So there are several ways to identify it. So the first one is back to the previous part. Who is mentioned or listed as the creator or the author? In case that the both creator or even more than two creators want to entitle themselves together to as the author, so then the authorship is owned by all of them, just like in Lennon McCartney. So Lennon and McCartney own the songs together as the copyright holder. Or like in Christine Kansil and C.S.T. Kansil, then both of them are the author and also the copyright holder of the creation or the works. Or in another situation, the mate of the creation is not distributed equally. I mean the portion of the making. So who would be considered as the owner or the owner of the creation then? Well, to discuss about that, you can take a look at Article 31 and 35 there, because it's talking about creation that made by more than one party. I mean especially Article 33, because Article 31 is focused on the situation when the name of the author is clearly mentioned. But what if it's not clearly mentioned in Article 33? First one, in the event that works comprise several individuals' part created by two persons or more, the one that will be regarded as the author is the person leading and overseeing the completion of the entire works. So in this case, maybe the creation is made by many parties, but or at least two parties, but some parties only play small part, and there is one person who actually lead the making of the creation. So the leader of the making of this creation would be considered as the author of the creation. Let's say that I am writing a book, and then I also ask my students to help me to find some particular resources, information regarding the book I'm writing. So they're helping me. They give me some input, some information, some creation. But then I'm the one who collected and lead the making of the creation. So the one that would be entitled as the author of the book is me. So there could be this kind of situation happen. So that's why when you make the creation jointly, you must make it clear with your partner. Would everybody involved will be entitled or as the author or just the leader? So it's back again to the contract. You have to make it clearly in the beginning, though it's just an oral contract. And another situation is that sometimes you make a creation because you work for someone or a company. For example, you work for a magazine, and then based on your contract agreement, your job is to create photographs for the magazine, so the magazine will use the photograph to publish it. Well, let's say that then you take some pictures of buildings or even animals, and then you give it to your company, to the magazine company. Well, then the magazine publish your photographs. So now the question is, whose copyright is that? Who owns the copyright of the creation? Who owns the copyright of the photograph? So to identify who owns this, I mean the creation here, the copyright. So all you have to do is to analyze the ownership of a copyright based on the working cooperation or working agreement. You can take a look at Article 35, and from this article you could try to find and identify who is the author. Article 35 verse 1 said, unless agreed otherwise, the copyright holder to works produced by an author under employment of civil service. Okay, the keyword here is under employment of civil service institution. The one to be regarded as the author is the government agency. What does it mean? It means that if you are a civil servant and then your work is to make works or creation that protected under the copyright, but you make it for your institution, which is the government institution. So the one who owns the copyright of the creation is not you, but the institution. Let's say that you work for Dikti, for example, the Educational Directorate of Indonesia, and then one of your job is to make articles to be published in Dikti website. So you make the articles, you make the creation, you make the scientific article, and then it's published. But because you published it as your profession of civil servants, and you create it because it's a job, your job description in your institution, which the institution is the government institution. So when you make the creation, so the copyright of the creation is belong to your institution, which means that they will be the one who has the economic right, the right to gain economic potential. Let's say that maybe the creation is sold, and then they will get the money for it because they are the copyright holder of the creation. They even entitled as the author. But there is one phrase here that you have to pay attention. Unless agreed otherwise. What does it mean? It means that you can set aside this provision and asking the institution to give the position of the author to you, but you have to clearly state it in the agreement between you and the government institution. Okay, do you get it? So if you want to claim the authorship of the creation, you have to tell the government institution, every creation I made, it will be upon my copyright. Well, then let's say what will the institution say. So that's why understanding contract is very important for you, because by knowing contract, you know how to protect your creation, because sometimes it's also implied not only by the civil servant but the private company or natural person that hired by government institution. So you can bargain here, you can make negotiation. But what if you don't clearly state in your contract that the copyright will belongs to you? So the law already regulated. So if you don't make it specifically in your contract, so the word unless agreed otherwise is not applied. So automatically the order is the government institution that hired you. And the other situation is in Article 36, unless agreed otherwise also, yeah, unless agreed otherwise. The other and the copyright holder to works produced under an employment relation or based on commission are the party producing the works. So it's different with Article 35. In Article 35, if you make a creation because the one who order you to make the creation is government institution, so when the creation is made, the copyright is owned by a government institution. But if the works is an order from a private institution like PT, yayasan or koperasi, a limited liability company, foundation or corporation, well then the one who own it is the one who make it. For example, there is a company, limited liability company, asking you to create a video for a company profile. So you are a certain company, another company that your job is, your services is making company profile. Or maybe you're just an individual outside the company, but you have the capability to make those kind of things. So they hire you, they contact you to make the video. So because the one who hire you is a private company, so when the video is made, then the one who entitled as the order is you. But again, unless agreed otherwise. So sometimes the company will offer you to make the video, but they will also say the copyright of the video will belongs to us, they said. And then if you agree, so you can set aside this Article 36, then the copyright will belongs to the company, because there is this preset unless agreed otherwise. Jika diperjanjikan sebaliknya in Indonesia, so you can set aside this provision and then you make it clearly in your contract that the copyright of the creation that made by you under the contract between you and the company will belongs to the company. But what if your contract never said about a specific thing about the ownership? So the law already govern it, and according to the law, if the creation is made in under the working agreement between the creator and a private institution, so the one who entitled as the owner is the one who make it, which is the creator. That's why understanding contract is very essential for you, yeah. Just like me, for example, a lecturer, I made many creation under the working relationship between me and the university. So by understanding this profession, I know who owns the copyright of my creation, which is me, unless based on the agreement between me and the university, it is clearly stated that every creation I made would be under their copyright. And that would be the main things that you need to know. And there are so many examples even in real situation about it, that you have to, that shows you that you have to pay attention. Let's say that there were situation about a lady working for a certain magazine in Jakarta. So he proposed his photographs to to the magazine. The magazine initially rejected, but then a few weeks later, the magazine used the photographs in their magazine. So then, this is the situation also based on the working cooperation. Then you have to know who owns the copyright here, which is the copyright is belongs to you, because this is based on the working relationship. And I would also like to give you an example, another example. If you remember, or if you ever heard about the money, Indonesian money, 10,000 rupiahs money, the old one, the old version, which display the face of Sultan Mahmud Badarudin II. There was a case about that Sultan Mahmud Badarudin painting. It's made by a painter from Palembang. So the case was started when the governance of South Sumatra Selatan is doing a competition to ask all the painters, many painters, to make the painting of Sultan Mahmud Badarudin, which is the national hero of South Sumatra. But actually there were no real picture of Sultan Mahmud Badarudin, so the governance is asking painters to make interpretation of the face. So how do they make the interpretation? They make the interpretation by the guidance of the family, the heirs of Sultan Mahmud Badarudin, the children of the children and of the children again. So they would explain to the painters how was Sultan Mahmud Badarudin look like based on the story of their parents, and of their parents again. And then many painters make the interpretation of the face, and the winner of the competition is Aden Arifin. So until that stage, no problem, Aden Arifin got the prize, and and the South Sumatra province got the pictures of Sultan Mahmud Badarudin, that the picture or the painting is used to apply for the claim. So the South Sumatra province is asking the central government to entitle Sultan Mahmud Badarudin as the national hero. So the central government need the painting of Sultan Mahmud Badarudin. So the painting from Aden Arifin is submitted as the painting or the representative of face of Sultan Mahmud Badarudin. Well, until that case, no problem. But the problem issued when Bank Indonesia then used the painting of Sultan Mahmud Badarudin II in the 10,000 Indonesian currency. You may take a look at the currency. Find the one that has this version of Sultan Mahmud Badarudin. So when the money was issued to the public, then Aden Arifin against the situation, because according to him, he deserved the royalty because he's the one who owned the copyright of the creation. So he complained to Bank Indonesia why Bank Indonesia used the picture of Sultan Mahmud Badarudin without his permission. So he submitted a lawsuit against the Bank Indonesia and also the South Sumatra province. So the case was then continued to the trial. But do you know what's the result? The lawsuit of Sultan Mahmud Badarudin is rejected. He lost because according to the judges and also based on the law, the one who owned the copyright of the Sultan Mahmud Badarudin painting is not Aden Arifin, but it's who? It's the family of Sultan Mahmud Badarudin. Why? Because in the law, at that time, I mean, we follow the law 19/2002. That is the old version of the law 28/2014. Well, actually, the content is also still there in law 28/2014. There is a part of the law that said, if the creation is made under the supervision of someone, so the one who considered as the author of the creation, he's the one who guide the making of the creation. So in the case of Sultan Mahmud Badarudin, Aden Arifin is only make the painting, but the painting is made because he got guidance from the family of Sultan Mahmud Badarudin. So the intellectuality creation here comes from the family of Sultan Mahmud Badarudin. So the family would be entitled as the author of the creation. It's also related to the case that when I told you about the architect. So the architect make the design, but the design is applied by the workers. But the workers could not claim it as their creation, right? Even though they are the one who realize it. But they make it because the guidance that given by the design from the architect. So it's just like the case of Sultan Mahmud Badarudin. Sultan Mahmud Badarudin, Aden Arifin is the workers, is the one who created, but he could made it only because the information, the guidance from the family of Sultan Mahmud Badarudin II. So here also you have to pay attention on the creation that made under the guidance. Maybe you need to also offer a certain provision in the contract before you make it. Just like in case of Aden Arifin, maybe Aden Arifin could also in the beginning make sure who will own the copyright, so there would be some negotiation of a contract there. Because if you don't make the negotiation of a contract to determine clearly who would be the author, then you have to follow the rule that the rule said who guide the making of a creation is considered as the creator or the author. You could find many other case examples, and if the session was conducted in class, I could even give you some song example, but because of my limitation in my house, I could not play you the songs to compare it. Maybe we will do it later in another occasion. So pay attention if you work for someone else's in making creation. In conclusion, when a creation is made by more than one party, so the one who would be entitled as the author is depend on the agreement between the all creators. Would all the creator mention as the author? Or maybe the creation is only led by one person and the other is only supporter. So the one who would be entitled as the author is the leader. Or if the creation is made under the working agreement, so the law already said if the working agreement is between government institution and another party, so the creation would be under the authorship of the government institution, unless it's agreed otherwise. As well as if the creation is ordered by the private institution, so the law already make regulation about that the authorship is owned by the creator. But if in agreement it's agreed otherwise, then it could be entitled the private company could be entitled as the owner of the creation. And also if the creation is made under a guidance, so the one who guide the making of the creation would be entitled as the author. So that would be the closing for this part. There's still many things to discuss further. I hope you still cheer up. Thank you.